Good day, everyone, especially to you, sir. Mr. Roger Anthony Gamali. Good day, sir. So now I'm going to report the whole chapter 1, which is the practice of forensic chemistry, collections of specimen to be examined. The fourth is 6 golden rules in the practice of forensic chemistry and equipment used in the forensic chemistry. So now let's start with the introduction. If the law has made you a witness, remain a man of science. You have no victim to avenge, no guilty or innocent persons to reign or save. You must bear witness within the limits of science. So, forensic chemistry is defined that branch of chemistry which deals with applications of chemical principles in the solutions of crimes. So, so the value of like the other forensic science, forensic chemistry plays a very important part in the speedy investigations and the administrations of the justice. It is well settled that this science has an advantage over structured confession, eyewitness, and other circumstantial evidence. So, thus, it is regarded as the highest form of uncontestable and conclusive piece of evidence with the utmost legal significance. So, the value of the findings of a chemist in convicting the guilty as well as in clearing the innocent suspect has long been recognized not only in the criminal investigations and detections but also in courts of law. So, the forensic chemist is often called to render testimony in court. So, forensic chemistry during an investigation. A forensic chemist is a professional chemist who analyzes the evidence that is brought in from crime scenes. So, and reaches a conclusion uh, based on tests run on that base of evidence. So, also a forensic chemist rarely conduct any investigate work. They handle the evidence collected from the crime scenes. So, and forensic chemistry is the science that deals with the study and application of chemical principles in the solutions of problem that arises in connections with the administrations of justice. So this forensic science deals with application of chemistry in the identifications of evidence. So its physical and chemical properties. So it is also include the collections, preservation, examinations, and study of blood. So semen and other body fluids, examinations of dangerous drugs. So examinations of body fluid to determine the presence of the dangerous drugs, alcohol, liquor test or liquor test. So examinations of fake products for unfair trade competition. So arson investigation, macro etch examinations, and bullet trajectory, and ultraviolet examination. So tolls and other marks, gunshot residues, gunpowder, nitrates, paraffin tests, distance determinations, and firearms examinations, and principles and examinations of explosive, hair and textiles fibers, chemical aspects of documents and examinations problems on glass fragment and glass fracture, moldage, metallurgy, and petrography as applied to crime investigations. So forensic chemistry also includes the study and examinations of dio, uh, deoxyribonucleic acid or DNA for brevity. So On the other hand, forensic toxicology deals with the examination of human internal organs or the food samples and waters and gastric contents. So for the purpose, for the purpose for the purpose of detecting the presence of poisonous substance, its dosage, effects, and treatment. So let's proceed to the practice of forensic chemistry. So the work of a forensic chemist is divided into four stages, which are the collections or receptions of the specimen. Second is the actual examination. Third is the communication of the results of the examination. And the last is, or the fourth is court appearance. So when we say collections or receptions of the specimen, the proper collections, preservation, and transportations of the specimens are essential. Ano ba yun? Um, Essentials in the investigations of a crimes. Hence, whenever possible, the chemist should personally collect of the specimen. So, so this then necessary for the examinations. This particular stage of the forensic chemist work is essential as question regarding the collections, preservations, and transportations of the specimen are raised during the trial. So, so the first collections or receptions of the specimen. It means the proper specimen collection and handling is an integral part of obtaining a valid and timely laboratory test result. So specimen must be obtained in the proper tubes or containers, correctly labeled, and then promptly transported to the laboratory. So there are four factors that must be considered when collecting specimen for examination. First is sufficiency of sample. Second is the standard for comparison. Third is the maintenance of individuality. And fourth is labeling and selling. So when we say sufficiency of samples, as much as possible, the investigator should collect sufficient amount of the specimen for examination. So this will make the chemist confident that in case of doubtful results, he or she can still have enough samples to repeat or to proceed to the succeeding examination. So it is also to collect the evidence that may help to prove or disprove a link between individuals or and objects or places. So second is the standards for comparison. So when the evidence in questions is located in or added with a foreign substance, a sample of such foreign substance must be submitted for analysis. So for the instance, if blood is found on linoleum, a sample of the unstained linoleum must be submitted together with the stained portion. So in cases of adulterations or unfair trade competition, a genuine sample must be submitted for the comparison. So in the examinations of the hair, textile fiber, soil, or etc., standard samples must be submitted for the comparison. So, um, so it is based or typical in cases of adulteration or unfair trade competition. So it must submit it for comparison. So let's proceed to the maintenance of individuality. So each piece of evidence must be collected and preserved as a separate sample. So there must be no mixing or intermingling of specimen collected from different locations as well as those of standard specimens. So, and the fourth is the leveling and selling. So, it is well settled rule that evidence will have no value in court in spite of the good report of the experts if the specimen cannot be identified by reason of improper labeling. So, hence, each sample must be labeled properly. So, small fragments should be enclosed in proper specimen boxes, container, and the boxes should be sealed. So, the label should include informations concerning the nature and the source of the sample, date, and time of collection. So, case number, if any, and name of persons collecting the sample. So, let's proceed the actual examinations of the specimen. So the first step in the examination of an article is to scrutinize it carefully and write down in the laboratory logbook or record book complete descriptions of the external appearance, including the manner in which it is secured and the particulars of the selling. So, if possible, take a photograph of the specimen, including the inner wrappings, and take note. Its descriptions are detailed. Descriptions of the appearance of the contents of the package should be noted and recorded. All wrappers should be kept and preserved since questions concerning them may be raised in court during trial. So, it means an examination is a formal test that it takes to show the knowledge of ability or ability in a particular subject or to obtain qualification. So, so the second steps of the actual examinations of the specimen. The second step in the examination is to measure or weight, or you get the weight, the object, and all measurements and weights should be entered in the laboratory logbook or record book. The specimen should then be placed in the proper container or wrapper and must be kept in the proper evidence room. So the third step is the laboratory examinations, so which consists of the chemical, the physical, and confirmatory tests. So, third, let's proceed to the communications of the results of the examination. So, the results of the examination conducted should be communicated with the requesting party in the form of a written report, which must include enumerations of facts on the specimen received for examinations with detailed descriptions of the packaging, selling and labeling date of receipt, and from whom it was received. So the purpose of the examination, the finding and conclusion. So, and the fourth is the court appearance. Court appearance. The written report of the forensic chemist is usually supplemented by testimonial evidence in a later date if the case is brought to court or the official's office. So, since the testimonial evidence may be given weeks, months, or even years after the examinations, and the written reports have been made, it is not only permissible but indispensable that the chemist should refresh his memory by referring to his laboratory record book before representing himself in court. So, um, so it means the formal act of going in front of judge to have one's case decided on. One man has been convicted of the crime and two others are awaiting court appearance. So that's what um, I understand on court appearance. So let's proceed to the rule. A forensic chemist in the scientific investigation. So a forensic chemist, as a man of science, performs laboratory examination on physical evidence submitted to the crime laboratory in order to expedite expedite the investigation of a crime by the investigating party. He or she has the following responsibilities. So there are 12 rule of forensic chemist. So first is conduct conducts the qualitative and quantitative determinations of abuse drugs as well as volatile substances. Second is the conducts chemical examinations of explosives and or explosive ingredients. So third is conducts examinations of paraffin, cast, and firearms to determine the presence of gunpowder nitrates. So, fourth is conducts gunpowder examinations on clothing for possible gunshot rings. And fifth is conducts toxicological examinations of human internal organs or gastric contents, blood, water, food samples, and other substances. Number six, conducts examinations of fake products in cases of unfair trade competition. Seven is conducts blood alcohol determination. Examines Number eight is examines urine samples and other body fluids for the presence of abused drugs. Ninth is conducts researches related to cases being examined. So 10 is testifies and gives expert opinions in court. And 11 gives lectures on forensic chemistry and chemical toxicology to various schools, universities, police training centers, and investigating units. And number 12, responds to queries of all investigating units and render expert opinion on matters related to the applications of chemical principles for the purpose of the existing investigators to develop investigative leads. So, so there are 6 golden rules in the practice of forensic chemistry. So first is go slowly. Go slowly. So good work um, cannot be hurried. Therefore, take all the time necessary to make the case complete, no matter how urgent it may be appear. It may appear. So, second is be thorough. So, make careful and minute examinations of everything, and do not be satisfied with a quantitative analysis if a quantitative one is possible. So it always pays to do too much rather than too little, and it is difficult to foresee that will or will not be required in court. So third is take notes. So when we say take notes, keep a full, neat and clean record of everything seen and done. So fourth is consult other. So it is many cases will lead the experts into paths with which he is not familiar, and when this happens, he should consult those who know better. So fifth is use imagination. So an expert with a wide and uncontrollable imagination is considered as the most dangerous creature. So thought his being imaginative is sometimes useful, and experts witness does not have to be solely imaginative, but he has to be skilled in the field of forensic science. So he must bear witness within the limits of science. So last is avoid um, complicated theories. So the simple explanation is fundamentally the right one. Interpretation of results is often the most difficult part of the expert task. That is why a wide knowledge and scientific experience are the essential elements to obtain the right forensic examinations results. So let's proceed to equipment, the equipment used in the forensic chemistry. So there are 5 equipment. First is so so the following are some of the most common laboratory equipments used in forensic examination. So first is high-powered liquid chromatography. So this scientific equipment is used for the qualitative and quantitative determination of a volatile or non-volatile compound based on the chromatographic separations of its components. Second is ultraviolet spectrophotometer. So it is used for the qualitative and quantitative analysis of organic compounds. Third is enzyme multiple assay technique. So it means it is used for screening of abused urine samples. And fourth is scanning electron microscope. So the scanning electron microscope. So this scientific equipment is used for the physical identifications of various um, questions of specimen. So it is the software controlled digital scanning electron microscope used to produce sticking images over the wide range of magnifications on raw or covered surface of minute specimens such as hair, fibers, paint, particles, drugs, and metal, or etc. So the last is Fourier transform infrared spectroscopy. Spectroscopy, no, like, yeah, spectroscopy, spectroscopy. So used for the identifications of pure organic substances. So it identifies organic substances, particularly abused drugs and explosive ingredients based on their characteristic functional groups in layman's terms. So the resulting spectrums could be referred to as the fingerprints of the substance. So that's all for the chapter 1. So let's proceed to the chapter 2. The preservations and shape-keeping of evidence. So the following are the guidelines and the proper preservations and safekeeping of evidence. So first is proper chains of custody shall always be observed. Second, all examined pieces of evidence, such as drugs and other paraphernalia, explosives, firearms, and all other chemistry-related evidence, shall be personally turned over by the examiner on case to the evidence custodians. The latter, in turn, shall execute its documentations by recording all receipts as well as release evidence for court presentations. No examiner shall keep in their possession evidence once examined. So third is evidence shall be properly placed in suitable dry containers for proper preservations and shall be placed inside the concrete evidence room. So the firearms evidence shall be kept in separate evidence room, especially in designed for that purpose. So however, the hazardous evidence such as explosives and other inflammable evidence are photographed after examinations with its corresponding case number before turning it over to explosive ordnance disposal unit with proper receipt for safekeeping or proper disposal. So that's all for the chapter 2. So let's proceed to the chapter 3, which is the development of scientific crime laboratory in the Philippines. So in February 14, 1892, massacre occurred in Chicago. Then a group of public-minded individuals was responsible for the establishment of a scientific crime laboratory in that city, which today has marked its place in the historical annals of police science. On March 31, 1876, creations of medicus titulars by virtue of Royal Decree number 188 of Spain. For every province, a forensic physician was assigned to perform public sanitary duties and at the same time provide medical legal aids to the administrations of justice. On December 15, 1884, Governor General Joaquin Haviliar created a committee to study the mineral waters of Luzon and appointed Anacleto del Rosario as chemist. So, on September 13, 1887, establishment of Laboratorio Municipal de Manila under the inspections of Directions General de Administración Civil and the control of the governor the provincials. The functions of the laboratory was to make analysis not only of food, water, and others from the standpoint of public health and legal medicine, but also of specimen for clinical purposes. In 1894, Laboratorio Medico Legal was created under the dependency of the judicial branch of the government, and the laboratory functioning under the directions of the physicians and assisted by a pharmacist chemist. So in 1895, Antonio Luna established a clinical laboratory where some original work and chemists were done. Unfortunately, all prospects of the advance of the scientific laboratories were paralyzed as a result of the revolutions in 1896. So, on 1899, the first scientific laboratory was established in a small building on the banks of Pasig River with the LT and the RP Strong of the U.S. Army in charge. So in 1901, actual scientific work began under the initiative of Dean C. Worcester by virtue of an Act number 156 approved by the Civil Commission. On July 1, 1901, the Bureau of Government Laboratories was created for the purpose of performing biological and chemical examination, so as well as for the production of vaccines and sera. March 11, 1915, the Department of Legal Medicine was created pursuant to the resolutions of the Board of Regents. The department took charge of the courses of the legal medicines and its branches in the College of Medicines and Law. On October 14, 1924, through the passage of Act Number 3043 by the Philippine legislature, the same Department of Legal Medicine became a branch of the Department of Justice and at the same time an integral part of the University of the Philippines. December 1, 1937, the Divisions of Investigation was created under the Commonwealth Act number 181 with two medical legal officers and a chemist. So the medical legal sections of the Division of Investigation started the definite movement towards the creations of scientific crime election detections, laboratory. So, September 1945, the National Bureau of Investigation, or the NBI, was organized with the divisions of investigation as the nucleus, the chemical laboratory of the medical legal section was expanded into a forensic chemistry division. So, at present, there are four distinct laboratories in the Philippines performing forensic chemical analysis. So, namely, first is Forensic Chemistry Divisions of the NBI, or the National Bureau of Investigation. Second is the Criminal Investigation Laboratory of the Manila Police Department. Third is the Criminal Investigations and Detection Laboratory of the Philippine Constabulary, Manila Investigation Service Laboratory. So, that's all for the chapter 3. So, let's proceed to the chapter 4. Chapter 4 is scientific evidence. So, evidence is a proof of allegation. It is a means sanctioned by law of ascertaining in a judicial proceeding the truth respecting a matter of fact. The sections Rule 128 revised rules on evidence. Corollary thereto scientific evidence may be defined as the means sanctioned by law of ascertaining in judicial proceeding the truth respecting a matter of fact wherein scientific knowledge is necessary, such as scientific evidence must have such a relation to the fact in issue as to induce belief in its existence or non-existence. So, evidence on collateral matters shall not be allowed. So, except when it tends in any reasonable degree to establish the probability or improbability of the fact in issue. So the evidence may be direct, indirect, which includes the circumstantial evidence or the hearsay. So when we say direct evidence, is that which the senses perceive any fact to which a witness testifies based on that he saw, that he heard, smelled, he touched, or tasted, is direct. No? So crimes are done secretly. Usually, the perpetrator seeks darkness and remoteness in order to cover his misdeeds, and in most cases, no witness is present. So, at the scene of the crime, or even if there is a witnesses, he or they are not willing to testify. So the necessity of resorting to the other means of proof is essential. So hence it is necessary to see all other available modes of procuring evidence in order to establish and prove a case in court. So circumstantial evidence is a kind of evidence which seeks to establish conclusions by the inferences from the facts proven. In illustrative cases, While a policeman was controlling, he heard a scream from a house. So he immediately proceeded to the house, and there he saw a man coming out of the house carrying a bloody knife. The policeman arrested the man and subsequently entered the house. There he saw a female cadaver lying on the floor with a stab wound on the breast. So in this case, the only direct evidence to which the policeman can testify would be to the fact that he saw the man with a bloody knife coming out of the house. So where the scream came from, the prosecutor may establish a conclusion that the man with the bloody knife is the criminal by inference from the facts testified to by the policeman. So under present law, circumstantial evidence is sufficient for conviction. So if there is if there is more than one circumstances, the facts from which the inferences are derived are proven, and the combinations of all the circumstances is such as to produce convictions beyond reasonable doubt. So when we say hearsay evidence, is a statements made by a witness on the authority of another and not from his own personal knowledge or observation. So hearsay evidence is inadmissible, admissible. So except on the following. First is dying declaration, rest geste, declarations against interest, act or declarations about pedigree, pedigree, family reputations or traditions regarding pedigree, common reputation, parts of res geste, entries in the course of business, entries in official records, learned critics, and testimony or dispositions at a former proceeding. So, forms of scientific evidence. So, real or autoptic, autoptic evidence. So, it is means that evidence which is addressed to the senses of the court. So, it is not limited to that which can be known through the sense of visions, but extends to the which are perceived by the senses of hearing, taste, smell, or touch. So, testimonial evidence. An expert may be called on the witness stand to answer all questions propounded by both parties in the case. So, in documentary evidence, any written evidence presented by an expert in court which is relevant to the subject matter. So, in dispute and not excluded by the rules of court, formal written report, expert opinion, certificates, and dispositions are included in this group. So the investigator is a fact finder. So it is basic that he must know the laws concerning the nature of his investigation. He should secure evidence in such a way that the findings can be admitted. can be admitted in court and remain impregnable against any attacks by the opposing counsel. So he should be in constant contact with various investigative and enforcement agency. So that's all. That's all my report. And once again, good day, everyone.